All right, this next section is the MPEP review. This is government representation of the things, but that's the main part. So starting out, we're going to talk about and this is also kind of goes with seeing about so Inventor being sort of registered practitioners within the same 10 or less patent practitioners can be named with their name and registration number. But if more than 10 names are listed, then the power of attorney accompanied must be accompanied with a paper which showed the actual 10. So even if you list 10 in, they're still not going to be happy about that. And you'll still have to choose just 10. So as far as signing papers, every paper that is filed has to be signed by a practitioner, except in this kind of repetitive, those which are required to be signed by the applicant. So the practitioner can sign almost everything, disclaimer, terminal disclaimer, but when it comes to filing a reissue, that's usually the assignee, especially where there's non-binding claims, any other declaration, as you can imagine, and then a declaration of facts not known by the practitioner. So even if it's communicated to them by the inventor, that doesn't mean that they have the right to sign it. So for the revocation of power of attorney, right, this can happen at any time for any reason, and this takes effect when it is received at the patent office. So it's not super clear as to whether you would be able to use certificate mailing principles on this sort of thing, but kind of just going with the mentality, okay, when the question says it's received at the patent office, that would be the day of the revocation of the power of attorney takes place. So if all the attorneys do not, if all the inventors don't agree to revoke the power of attorney, then one of those inventors can submit the revocation with a petition and a plea, versus otherwise you just, all the inventors would sign a petition to have the power of attorney revoked. But in this case, if somebody wants a new lawyer for good reason, they can submit a petition to the director and a plea. And so then it's again a little bit vague on here in the MPEP as far as what happens, but more than likely that other inventor would assign their interest or would give power of attorney to someone else. And so in that case, multiple attorneys would probably need to sign the papers going forward. So then in a continuing application, you can use a power of attorney copy from the parent and must identify any change. And you can do that unless that QA was granted by the inventor and the continuing application added an inventor, right? So in that case, you would need a new or additional power of attorney and not the other one would not work any further. It's also treated, if there's a new one filed, it's treated as a revocation of that original one. So I think it's a really good area for questions in that kind of determining who the patent is finally assigned to when there are multiple power of attorney, multiple practitioners on case. It's going to be the latest one added. However, there is an example in the MPEP about a power of attorney that's filed with 2 practitioners. And so let's say the original was filed in January and then in March, another one was filed. If another one was filed without the original one also listed, then that original one, his power of attorney is revoked. However, if that additional one is filed with the January one and the March one listed, then that's okay. Then they can both maintain their power of attorney status, but the correspondence is now mailed to the latest correspondence of record. So that second attorney is who's going to get the mail. So for attorney withdrawal, this is going to take effect when the director approves. So remember, PTO, when they receive it, that's the case for revocation by the inventor or whoever else. But for the attorney withdrawal, when they're putting in that petition, that takes effect when the director approves. And the practitioner, in order to withdraw from representation, they have to give reasonable notice to the client prior to expiration. And I've seen some things saying 30 days is best, but it's not really clear in the MPEP that there's like a statutory limit as far as how long they have to give the client. But basically, they have to give reasonable notice to the client. And it's prior to the expiration of a reply period, which can be obtained by petition and fee. So if you're at the end of 3 months of a statutory period, the client would still be able to get another 3 months. And so in that case, they're giving enough time is kind of my understanding there. Hopefully that makes sense, but definitely feel free to read that section on your own. Delivery to clients, all the papers, properties, and funds, making sure that they know how to access everything and knowing of any replies that are due and any of the due dates that are coming up. So basically, pretty obvious here, I think, just like informing the client as much as possible as far as what their status is before dipping out. So for the substitute statement, this kind of goes along with this chapter. When the inventor is dead or insane or legally incapacitated, substitute is submitted under those three rules, 1.43, 4.5, and 4.6. And so this substitute statement can be submitted up to an issue fee. And so that's the same with the oath or declaration, right? So you can submit that up to the issue fee now. But then as far as what happens if the inventor dies before the patent issues, that power of attorney, if it was just one inventor, is automatically revoked, unless that attorney had some sort of vested interest in the patent, or there's a joint inventor that was also had power of attorney, or had also given power of attorney, and so that would still be maintained in that case. And then if that does happen before issues, or maybe they had just gotten an ex parte quail, it will still proceed to issuance. Like a notice of allowance will still be mailed, and it'll still issue it as long as the issue fee is paid. So it doesn't necessarily stop everything if someone dies. So then as far as who, these are, I think, some good just red line rules to follow. For 1.43, under 1.43, a legal representative would sign in the case of a dead or incapacitated. So whoever is controlling the will or an heir is basically just whoever is kind of taking the place legally of that person after they've died, or has been just appointed to take care of their affairs. Under rule 1.45, that's going to be a joint inventor who can sign. So they're saying, hey, we're unavailable to find this person, or yeah, they invented it, but they won't sign the other declaration. For 1.46, that's when the application can be filed by the assignee or others with interest. And so they can submit the substitute statement in that case. That's only post AIA. And it can also be signed. So as far as the person with interest, they have to submit a petition with a fee and their showing of interest, versus the assignee, they just have to check a box, basically, is what they have to do in order to kind of show their interest. And I think they have to show proof of assigning, but a person of interest has to give a lot more information as far as why they're interested and how this will protect the rights of the original inventors. So for the interviews, this is just kind of briefly gone over in MPEP 400, and it's also gone over in much more depth in 713.05. So the patent practitioner, that's an obvious one. That's who the interviews are typically with, the one who is listed in the case who has the power of attorney. The next person that can do it would be a registered practitioner who has proper authority from the applicant or the attorney of record. So there's a question on one of the old exams where somebody can't, the inventor and the patent practitioner, neither of them can make it to the interview. And so he asks another guy at his firm who's a patent practitioner, a registered patent practitioner, to go and gives him a copy of the application. Some things in MPEP 400, it said whether or not they bring the copy of application to interview, they have to bring authorization. So it's not super clear whether you have to bring the copy of the application, but I think you'd want to. I think to err on the safe side to show that you know the information you're doing. But office employees are forbidden from communicating with an unregistered, suspended, excluded agent unless they have some part of the application. And the power to inspect is not sufficient authority for granting an interview. I threw that in here. I don't remember if it was in the 700 chap part or the 400 part, but it was in all caps. And so I thought I'd throw that in here it's a good reminder that even if a power inspect is given, that doesn't mean that person is automatically in charge of the application or has any sort of power. So for ethics, this has been, kind of put with chapter 400 just because it is related to attorney, kind of attorney-client privilege sort of thing. So there's a new rule, Rule 1118B. And so this rule
I'm not sure when it took effect, but it had it just kind of laid out exactly what the law is. I think a lot of it is pretty obvious, but there's some good things to kind of remember, that a patent agent or attorney, they can take a reasonable interest in a patent or application as a part of the fee. And so there's some example questions I've seen where that is, worked out as an arrangement. But if a question does list that as an option, it's whichever one is probably the most modest, really, or it just seems to be the most fair. Hopefully it would be a pretty black and white question in that case. And you shouldn't submit anything, this again is pretty obvious, that isn't true, submitted for improper purpose. So anything that would be submitted as delaying when you should just be doing a suspension of action. Anything that violates the PTO rules, and then we of course have a duty to disclose any of that unprivileged information which establishes a violation. You can't prosecute trademarks. You can advertise, but you have to advertise with your name and make it clear you're a patent agent if you're not an attorney, and that you can't practice trademarks. You have to maintain a separate account or fund, so no commingling client money with attorney money. And then if there's a conflict of interest, I think that there's a lot of examples out there as far as what conflict of interest looks like, but basically it seems like best practice is to just inform previous and current conflict parties, kind of just letting everybody know, hey, this is where I'm at. Are you okay if I participate in this prosecution? Or, kind of however that needs to happen, but informing wherever you can, I think is just the rule of thumb there. And that is it. So kind of a quick one, but hopefully it helps, and hopefully none of anything that's ethics will be pretty clear. All right, thank you. Bye.